Hello everybody. I think you're gradually being led in to this webinar. For everybody who doesn't know, my name is Nicola Carvot and I have the pleasure of welcoming you to this webinar and also introducing our speaker, Dr. Ben Hayward. And given that we're running a little bit behind already, I will press ahead. So Ben is a senior lecturer in the Department of Business Law and Taxation here at the Monash Business School. His research interests cover international sales law, international commercial arbitration and private international law. And he's a particular interest in the CISG's rules for application, which is what he'll be talking about today. Ben's prior research has been published with Oxford University Press, Hart Publishing, in the Federal Law Review, the Sydney Law Review and the International and Comparative Law Quarterly. And he's recently contributed a submission to the Hong Kong Department of Justice consultation on the potential extension of the CISG to the Hong Kong Special Administrative Region. The presentation that Ben is giving today will address the CISG's application to international data trade, and it relates to a project that he's been working on at the Monash Business School for the past 18 months. A project that he intends to publish in 2 journal articles over the coming year. Ben is a co-director, along with myself, of our International Trade and Commercial Law Research Group, which along with the Department of Business Law and Taxation is hosting today's webinar. So I think Ben is going to present for about 35 to 45 minutes, after which we're going to have some time for questions and discussion. If you'd like to pose questions in the chat function as Ben talks, I can collect these up for Ben to address after he's finished his presentation. And of course, I'll take questions at the end as well.
So thanks very much, Nicola, for the introduction, and thanks everyone for coming along today for my presentation titled "To Boldly Go, Data as the CISG's Next but Probably Not Final Frontier." And thanks to the department and our research group for hosting today's webinar. So to get started, I know many of you here will be familiar with the CISG, the United Nations Convention on Contracts for the International Sale of Goods, but just in case you're not, I thought we'd start with a little bit of background. The CISG was concluded at a diplomatic conference in Vienna on 11th of April 1980. That's when its text was settled. And after it achieved the required 10 ratifications, it came into force at the international level on the 1st of January 1988. And it currently has 94 signatory states after Portugal most recently exceeded in September of this year. And the countries that have adopted the CISG are believed to account for approximately 80% of the world's traditional goods trade, at least presumptively. It's always open to parties to opt out of this treaty's application in their contracts, but presumptively it covers the vast majority of the world's traditional goods trade. And for those of us located in Australia, you might be interested to know we adopted the CISG shortly after it came into force at the international level, and it came into force locally here on the 1st of April 1989. And the reason for the treaty's existence is it's an instrument that's intended to facilitate trade. So the idea is if merchants are engaging in cross-border trade, every country is going to have its own sale of goods law. And merchants dealing cross-border might encounter different laws in every country in which they trade. Encountering all those different laws increases the costs of doing business, it increases transaction costs, and it hinders trade. And the idea is if the law is the same in countries in which merchants deal, then transaction costs are lowered and trade is encouraged. So the CISG is intended to provide a harmonised set of rules for international sale of goods transactions. So I mentioned that the CISG was formed, or it had its text settled in 1980, and the world's goods trade and the state of technology was very different at that time. And on the slide here, I've got a few things that were happening around the drafters of the CISG in the year 1980. 1980 saw the launch of Commodore's VIC-20 and Sinclair's ZX-80, 2 home computers that are featured on the slide here. I have fond memories of my own parents bringing home a Commodore VIC-20 that they'd picked up in a garage sale one day. It was antiquated even at that time. 1980 saw the launch of the world's first microcomputer hard drive with a total capacity of 5 megabytes, about 5 standard floppy disks, which is insignificant compared to today's storage standards. And also we saw the introduction of technology that was a predecessor to the World Wide Web. Of course, today's digitalized world of trade is very, very different. And trade in software, for example, is something that wasn't foreseen by the drafters of the CISG. A paper by Fairley commented that the significance of software was only foreseen by a few far-sighted individuals at that time. And today, digitized trade is really, really important in economic terms. And we've got just a few examples on the slide here. The Apple App Store is said to have had 180 billion cumulative app downloads as of June 2017. According to the Recording Industry Association of America, in 2014, the music industry saw digital format sales reach parity with physical format sales for the first time. And business digitization efforts in general are seeing businesses capture large amounts of data that's really useful for their various activities. And this data being collected is being called the new oil. So we all know from our everyday lives that data is regulated by privacy laws, but what about this emerging trade in data? What law regulates that data trade as between private contracting parties? So the question I'm posing in this research project is, can data constitute goods for the purposes of the CISG and therefore benefit from the harmonised sales law regime that the CISG establishes in the same way that traditional goods trade is intended to be benefited? So the significant body of scholarship addressing the CISG's application to electronic software trade is the starting point for my project. Now, this isn't the question I'm asking. I'm asking whether the CISG can govern data trade in general, and software trade is just one type of trade in data. But there is a vast body of scholarship and also a number of cases that address whether the CISG can apply to electronic software sales. And the view isn't universally accepted, but the generally accepted view is that yes, it can. And we can see the reason from this from the Schlectrium and Schwenzer commentary, one of the world's key authorities on the CISG. And according to that commentary, even if a subject matter of commercial transactions was not foreseen at the time that the CISG had its text settled in 1980, in order to determine whether it can apply to that kind of trade, whether the subject matters are or aren't tangible isn't the decisive criterion. Of course, in 1980, that's what they would have been thinking about, tangible goods trade. But what we're asking in order to give the CISG its own autonomous meaning is whether the provisions of the convention, and in particular Article 35 of the CISG, its rules on non-conformity, whether they are suitable to govern the type of trade in question. And it's widely accepted in relation to software that the answer to that question is yes. The rules on the CISG, I should say, can be adapted to software trade. Now, this isn't the question I'm looking at in this project. It's well established, I think, that the CISG can govern software transactions, but software is just one type of data. And if we think about what we mean when we talk about software, it has a particular connotation. You might be inclined to think when we talk about software of traditional desktop computer programs represented by executable files. And much of the literature addressing the CISG's application to software actually makes that presumption that we're talking about traditional computer programs. There are some contributions to the literature that take a broader view. I've given some examples on the slide here. But for the purposes of my project, I'm taking it as given that the CISG can apply to software, but I'm distinguishing that from what I'm calling non-software data, other digital assets that we wouldn't consider to be software in that traditional sense. So digital items that can be the subject of commercial trade that aren't traditional executable computer programs. And the examples I'm looking at in my papers are apps, media files that could include audio, video, image and document files, and also raw data that could include personal data. So I'm looking at whether we can take the next step beyond software and see whether the CISG can govern these kind of items as well. Now, there is an emerging body of scholarship looking at how the CISG might apply beyond software in that traditional sense, but it's not really very cohesive yet. So the most recent edition of the Kroll, Mastellis and Visicilis commentary on the CISG, the second edition published in 2018, makes very brief reference to the idea of digital goods, citing a German language article by Eggen published the year before that looks at digital goods specifically, but doesn't undertake a detailed analysis of whether the CISG's provisions are suitable for this kind of trade. Professor Schroeter, in an article the year earlier, had a one-page discussion of what he called digital content in another German language publication. He suggested that the CISG probably could apply, but it might not be an optimal regime. Earlier on, the Ancestral Working Group on Electronic Commerce made very brief reference to the question of whether the CISG can govern trade in what it called virtual goods, but concluded that it probably didn't, but gave no reason other than their intangibility. Probably the most significant recent analysis is an appendix contained in the German language edition of the Schleichtrium, Schwenzer and Schroeter CISG commentary, the German edition of the text I referred to earlier. It contains an appendix to its discussion of Article 1 of the CISG, specifically addressing data trade, but it assumes that answering the question of whether the CISG applies to software also answers the question of whether it applies to data. Now, I say that assumption is doubtful because software and non-software data, in my view, are qualitatively different. If we look at the examples of non-software data that I'm considering in this project, software is functional in and of itself. Apps are also functional in themselves, but they're not represented by executable files. Personal data, raw data, and media files aren't actually functional. They need something to be done to them in order for them to be useful. So they need to be accessed via or processed via an app or software. So they're different things. And if the question we're asking is whether the CISG's terms are capable of adaptation to the particular type of trade, that important difference between software and non-software data means that we can't automatically assume that non-software data is also within the CISG's scope. Most recently, Trackman, Walters and Zeller published a paper this year where they talk about the CISG as a tool that might help protect personal data, but they didn't actually engage in an exercise of interpreting the CISG to work out whether it can actually legally govern that type of trade. They assumed as a matter of commercial convenience that it can. So the existing scholarship doesn't really define often what it means by data. It doesn't analyse the CISG's application comprehensively, and in some cases it focuses on particular types of data like raw data and personal data. So my project wants to fill this gap in the literature and bring a bit more of a systematised approach to answering this question. So as I mentioned, I differentiate software from non-software data. I'm accepting the CISG's application to electronic software trade and asking the next question, can it govern trade in other types of digital assets? So what I'm doing is I'm asking whether these digital assets are goods according to the convention. That's the threshold question. And if the answer is yes, then as a matter of principle, this trade can be within the convention's scope. And to do that, I'm looking at whether certain provisions that Edgardo Munoz recently analysed In the software context, in a paper published last year, I'm analysing whether those same provisions he said can apply to software, whether they can also apply to other types of data. I'm also looking at whether data transactions might satisfy the separate criteria of being subject to a sale, and also whether they would or wouldn't infringe the rules regarding mixed contracts under the CISG, where contracts have a mixture of goods and services components. And these two criteria don't stop data falling within the CISG as a matter of principle, but they do determine whether particular contracts are inside or outside of the CISG scope. And this framework will allow us to answer some difficult questions about data under the CISG that currently aren't settled, such as whether cryptocurrency transactions can be within the convention's scope. In doing this, I also have to acknowledge some policy issues surrounding progressive interpretations of the convention. So Maya acknowledged in 2009 that there are some problems with taking too progressive approach to interpreting the convention's scope, because the CISG is a treaty that's meant to benefit trade, but we also have to keep in mind the interests of the countries that adopt this. They're bound by this treaty at public international law, so they need some certainty about when the convention applies. So Maya advocated a more restrained, incremental approach to interpreting the CISG's application. And I argue that's what I'm doing here. It's an important step, but only an incremental step beyond the already established position that software can be governed by the CISG. So as I mentioned, the threshold question is whether data constitutes goods under the convention. And this criterion comes from Article 1.1 of the convention. So the provisions you can see listed on the slide are those that Edgardo Munoz analysed in his recent paper in the software context. And in my paper, I'll be demonstrating that all of these provisions are also capable to adaptation to forms of data that aren't software. And for the purposes of today's presentation, because it's the provision that's singled out in the Schleicher and Schwenzer commentary, I'm going to be focusing on the CISG's conformity rules in Article 35. So Article 35 tells us when goods conform to the requirements of the contract and the convention. And under Article 35.1, goods have to satisfy the requirements of quantity, quality, and description that are set out in the contract. And they also have to comply with the packaging requirements set out in the contract. And though these criteria were formulated with a view to regulating traditional physical goods, they're capable of adaptation to the data context. So in terms of quantity, this would adapt depending on the type of data we have. So for raw data, it could be measured in file size or the number of entries in a database. For apps, it could be the number of apps transferred or the number of devices that an app is authorized to be used on. In relation to media files, again, it could be the number of files transferred or the number of devices that files are authorized for use on. It would adapt depending on the contractual specification in any particular contract. In terms of quality, we know from scholarship addressing traditional goods that quality can include non-physical features of goods. So for example, many authorities agree that ethical infractions in supply chains can lead to goods failing the quality standards in the CISG, even though the goods themselves might have nothing physically wrong with them. So if we transfer that notion over to data, we're going to be looking at whether these digital assets can fulfill their commercial purposes. In regards to description, this, for example, could involve whether media files have been provided in the contractually specified file format, and even packaging, which most obviously relates to physical goods, that can even apply here. The literature tells us that packaging will depend on the particular type of goods, and here with digital assets, they still have to be put together according to some kind of digital structure, and the contract will tell us how that is to occur. So for Article 35.1, we can see that those notions of quantity, quality, description, and packaging under the contract are transferable to the digital sphere. Under Article 35.2, there are default conformity standards that apply unless the contract provides otherwise. Under Article 35.2a, goods have to conform with their ordinary purpose. In Article 35.2b, goods have to be fit for any particular purpose made known. Under Article 35.2c, goods have to conform with the qualities held out in a sample or model. And in Article 35.2d, goods have to comply with packaging requirements that are usual for those types of goods. Again, all of these can be applied in the digital context. So in relation to the ordinary purpose, this will depend on the type of digital asset we have. An app will need to be fit for its ordinary commercial purpose. Media files will need to be able to be accessed at a baseline level, and some types of media file may have additional ordinary purposes. So for example, files transferred for the purposes of digital CPD activities, which many of us are engaging in far more frequently now as a result of current COVID-19 physical distancing requirements. They might only meet their ordinary purpose if they are recognised by the relevant accrediting body. In regards to a sample or model, we've got a really good contemporary example of this in the digital asset space in relation to apps. It's common for apps to be provided that are free and that have limited functionality, which are intended to induce customers to then pay for a full version of that app with expanded functionality. And we might say that they are effectively a sample or a model for the purposes of Article 35.2c of the CISG. The full paid version of the app would need to have the qualities that were held out in that free sample or model. And of course, the free version of the app would only be an approximation of the full paid version because it would have limited functionality, and that would be taken into account in applying that standard. In relation to 35.2d of the CISG, packaging, here again, we'd have to take into account what is usual for the type of digital asset we have. And since we're looking at a default standard here, rather than what's set out in the contract, we would have to consider, for example, the internet infrastructure in the buyer's country, and perhaps whether the file sizes we're attempting to transfer will be accessible at the buyer's end. There's a couple of other things we can say about these default standards. One of the objections to the CISG applying in the software context is that its conformity requirements are strict liability. But the literature does actually tell us that, for example, under Article 35.2a of the CISG, that goods have to be reasonably fit for their ordinary purposes. And that allows us some flexibility in the digital space to take account of, for example, the commonly accepted market practices in the app market of issuing updates to improve functionality, fix bugs, and address security vulnerabilities. So it may not necessarily be under the CISG that an app has to be perfect on day one. Whether it's fit for its ordinary purpose would take into account the accepted market practice of updating apps. And also something else we might want to consider is, does the provision of data, perhaps raw data or personal data, in breach of privacy regulations breach the CISG? And here we can again analogize with traditional goods and the New Zealand mussels case, which tells us when goods have to comply with public law regulations in the seller's country and in the buyer's country. And we can apply those principles to privacy regulations, which would be public law regulations in the buyer's country and the seller's country. So we have an answer to that question as well. Under Article 35.3 of the CISG, there is a safe harbour against liability for breach of the default standards, but not for breach of the contract's actual terms, where the buyer knew or could not have been unaware of the lack of conformity at the time the contract was concluded. And this is also applicable to the data sphere because its rationale is equally applicable. So the idea here is that a buyer is normatively justified of being deprived of its default protections when it knows the goods don't live up to those already, but a seller should always be held to the provisions of the contract that they've specifically agreed to. And that rationale is equally applicable in the data space. So what I'm showing in this project is that the provisions of the CISG, and we've talked about Article 35 here, can be adapted to types of data other than software. And so as a matter of principle, the CISG can apply to those digital assets. They would be considered goods for the purposes of the convention. As I mentioned, though, there's an additional criterion that goods have to be sold, and this will determine whether particular contracts fall inside or outside the CISG scope. So this arose as a particular difficulty in the software context because software is traditionally licensed rather than sold. That's a feature of the market. And the teachings tell us in that context that it doesn't matter what the transaction is labeled as. We're asking whether a license is a sale in substance. And for that, we're looking at whether there's a permanent transfer of the software such that it becomes part of the other party's property. And what's not included is an agreement for temporary use against payment of royalties. So we can apply those same criteria to non-software data to see whether those contracts would fall in or outside the convention scope. So for example, subscriptions to commercial databases of the kind that law schools and law firms, government departments, hospitals, other big institutions subscribe to, they wouldn't be sale contracts for the purposes of the CISG, even though data is goods, because they involve a periodic payment for access to data rather than data being transferred to those institutions permanently to become part of its property against a one-off fee. So an interesting case study here involves looking at the Apple Media Services terms and conditions. And I should mention, I'm specifically looking here at the Australian version. There may be regional differences around the world. The provisions that I've got summarised on the slide here are from the Apple Media Services Terms and Conditions for Australia. And it's interesting to see how these stack up against the sale criteria that we've just discussed. So those terms and conditions provide that the content is for personal, non-commercial purposes only, except for App Store content. So that's important because it means that App Store content isn't necessarily excluded by Article 2A of the CISG and its exclusion of consumer contracts. The CISG is only concerned with commercial transactions. It says that apps are licensed and not sold, but we know that that's not the definitive point. It's about whether the transaction is akin to a sale, even though under these conditions it's being called a license. So the terms and conditions make provision for in-app purchases, microtransactions. They also make provision for re-downloading previously acquired content onto a device that had previously had that content, or perhaps a new device, but no guarantee is made as to the continued availability of that content for re-downloading. And then interestingly, the CISG's application is expressly excluded from the terms and conditions. So if we have an app that is paid for, it becomes permanently downloaded onto a user's device. It is also available for re-download onto other devices by the same user. We might say there's a good argument that there's been a permanent transfer of that app for a single payment, and therefore it satisfies the requirement of a sale under the CISG's own understanding of that term. If a free app is downloaded, then the CISG requires a price for there to be a sale of goods contract. So it wouldn't apply, or wouldn't presumptively apply in that circumstance. But if a free app is downloaded and money is paid for a micro transaction within that app, well, that micro transaction might itself be a sales contract for the purposes of the specific microtransaction content. And it's not unlike purchasing a component part that's going to be subsumed within a larger machine. Then we might look at this express exclusion of the CISG. This is really interesting because we do know from empirical study, and John Coyle's study of US contracting practices in 2016 is a good example. We do know that parties can sometimes exclude the CISG in their contracts when it doesn't otherwise apply. So the fact that the CISG is expressly excluded in these terms doesn't definitively show that it would have otherwise applied, but at least gives us some commercial credibility plausibility for the argument that businesses out there in the market do believe that the CISG could potentially apply to these kinds of transactions. So as I said, it's the goods criterion that we mentioned before that will tell us whether or not these digital assets are in principle within the CISG scope. This sale requirement will tell us whether individual contracts are or aren't within the convention's regime. And the same is true for Article 3 of the CISG and its rules on mixed contracts. These are particularly important because tech transactions are seen as blurring the line between pure goods and pure services contracts. We might often see contracts where there's both. So some of these services obligations that might be attached to data contracts are listed on the slide here. Under Article 3.2 of the CISG, these mixed contracts are excluded from the convention's scope when the services element is the real gist of a transaction. So just like a marketing research report that's delivered by way of a physical stack of papers, those papers are goods, but that contract isn't within the scope of the CISG because the services sitting behind that stack of paper are the real purpose of the content. Of the contract, I should say. Similarly, a marketing research report delivered by way of an electronic document file, which my analysis says is data and would be goods, that's still not within the CISG scope because of that same rule of the CISG, Article 3.2. And then in Article 3.1 of the CISG, where goods are being manufactured or produced, if a buyer undertakes to supply a substantial part of the materials necessary for the goods, the CISG doesn't apply. So in the data context, say if a buyer supplied an essential part of the code that is reflected in the product that is then transferred back to it by the seller, that may result in the CISG not applying because of this Article 3 rule as well. So what can we say by way of conclusion? Well, my research will demonstrate that in addition to the CISG being capable of governing electronic software trade, it can encompass trade in digital assets other than software. The kinds of examples I'm giving in my research, again, being apps, media files such as audio, video, image and document files, and also raw data, including personal data. And I say this represents another example of the CISG adapting to changing times, an incremental advance, but still an important advance. So notwithstanding the fact that the CISG was developed in the same year that saw the launch of the Commodore VIC-20, the ZX80, the world's first hard drive, the predecessor to the World Wide Web, we've seen that it's been able to support electronic contract formation, support smart contracts, according to a really interesting analysis published by Duke last year. We can see that it can deal with electronic forms of writing. As we've said, it governs electronic software trade. This is then the next step in the CISG's adaptation to changing technological circumstances. And there's a number of advantages to this analysis. As I mentioned, it's an incremental advance, but it's still important. It avoids the terminological issues about what is software that have plagued existing analysis. It avoids the intentional or unintentional exclusion of other types of data from that analysis by virtue of using the term software. And by focusing on data as a fundamental unit of trade underpinning both software and non-software data trade, it's technologically neutral. And that's important because the list of tradable forms of non-software data isn't closed. My analysis would avoid the time-consuming and costly process of developing further uniform law tailored specifically to data. We've got the CISG already in existence and already adopted by 94 nations around the world. And there have been a range of other mold-breaking usages of the CISG. It's used as a template for all kinds of other law reform initiatives, as a teaching tool, as a tool for contract drafting. So as I said, it's an incremental next step consistent with prior development of the CISG's use. And finally, something else I'd like to mention just as we conclude is a possible macro level benefit. By accepting that the CISG can govern trade in data, this kind of innovative application of the CISG to what is now routine data trade may help promote its use and its internationally minded interpretation in countries such as Australia that have had a bit of a checkered past in dealing with the CISG. It's believed in Australia, for example, that commercial parties don't often use it. When cases do come before the courts, it's often treated as if it's the same in effect to our local Sale of Goods Acts, and that's not how the CISG is meant to be interpreted. That's the subject of some different research that I'm about to publish in the Melbourne University Law Review with two legal practitioners, Andrea Anastasi and Stephanie Peter Brown. But if we accept that the CISG is capable of operating in this digital space, it might give the CISG a bit of a spur in this jurisdiction and others having similar difficulties. So I'd like to conclude my remarks today by going back to the title of my paper, which you may have gathered borrows some iconic lines from the Star Trek science fiction franchise. And I do note the deliberately intentional irony here that Lieutenant Commander Data is one of the characters in that universe. By governing data trade, the CISG can go boldly where no sales law has gone before. And this is another example of the CISG adapting to the changing times. And by continuing to adapt to the changing circumstances of technology, we might say this is the CISG's next frontier, but hopefully not its final frontier. So this brings me to the end of my prepared remarks. I'd like to thank everyone for coming along and hearing about this research project. If anyone would like to follow up with me afterwards, my email address is on the slide here, benjamin.hayward@monash.edu. But for now, I'd be very happy to take any questions. I might stop my slideshow share so that we can perhaps see a few more of us on the screen. As Nicola said, she'll be managing the question and answer portion of today's session. So Nicola, I might throw back to you at this stage.
Thanks, Ben. That was a great presentation. And as a Star Trek fan, obviously I'm a great fan of the title, especially. So thank you.
Thanks, Nicola. And I know you're very well aware that Star Trek isn't actually my own forte, and that's about the extent of my knowledge. So I'm glad that a Star Trek fan is able to still appreciate it.
Yeah, well, you nailed it. So that's great. And thanks for the benefit of your analysis as well, which I think was really interesting. So we've already got one question on come through the chat. So perhaps I'll hand over. Is Kang still here? Kang Swante?
Yes, I am.
Would you like to ask Ben your question?
Yeah, sure. Thank you, Nicola. Thank you, Ben, for the excellent presentation.
My pleasure.
The sale of goods is something that I've studied in the university years ago, so I'm interested in it. But going straight to the question, you were saying that apps which are predominantly licensed are considered as sale. Now, if I'm going to draw the same analogy for this, property, a house or an apartment, which is typical, which if I rent it out, would it be considered a sale as well? Are we stretching this too far in that respect?
Yeah, it's a really, really great question. If we accept these interpretations, where does the line get drawn? And is there an unintended consequence of capturing things that actually aren't well suited to this regulation? So in terms of, for example, leasing out a property, one problem there for characterizing that as a sale is it would be a periodic payment against periodic usage. So wouldn't meet the CISG's definition of sale in that regard. And it would also be excluded from the convention scope for another reason, in that real property isn't considered goods under the CISG. But the reason why we can give it this broader scope to treat some licenses as sales in certain circumstances is the principle of autonomous interpretation under the CISG, which tells us that the CISG is given its own interpretation, not less necessarily the same interpretation we would give the terms in any particular country's legal system. So, for example, in under the Australian Sale of Goods Acts, those particular transactions, even those particular licenses may not be considered sales, but they maybe still could be for the CISG. But in your specific example, yes, we wouldn't have the risk of those transactions being governed by the convention.
Thank you, Ben.
Thank you, Kane. Can I invite anybody else? Does anybody else have any questions for Ben?
Hi, Nicola.
Hi, Rebecca.
I just want to thank Ben for a very interesting and insightful and thoroughly comprehensive presentation. Thank you. That is really fantastic. I agree with you completely that the CISG, even though it's a comprehensive international legal instrument, needs updating. So its scope application undoubtedly needs to be aligned with the demands of the modern international sale of goods. But I was wondering, or rather I can detect a little bit of tension between this need to expand the scope of the CISG with what is actually happening at the practical level. We are all aware of the reluctance at the practical level to apply the CISG where it is necessary. So I was just wondering whether it is feasible for the time being, or whether this would be better be dealt with a separate international legal instrument. So what are your thoughts on this?
Thanks, Jadranka. That's some really great questions. And I guess one of the advantages of the approach I'm suggesting is that you avoid the time and cost of going through that additional lawmaking process, although it would probably result, there are attractions to that, and having a regime specifically tailored to data from the outset might not only result in some better rules, but it might mean that it's more visible to traders and courts and arbitrators as well, in terms of being more obviously applicable. And I guess that goes to the point you make about the fact that, at least in Australia, the CISG perhaps is underused at the moment. On the time and cost point, I guess it took us between 1980 and 1988 for the CISG to get the 10 required signatories or accessions to actually come into force. And then it's taken us 40 years in total this year to get up to 94 contracting states. And in relation to cost, there's estimates in the literature that preparation of the CISG was costed at around $6 million US in 1980 terms. And I've corresponded with one of the authors who's put that figure forward, and he suggested that his understanding is that that relates to just the cost of running the UN meetings for the diplomatic conference. So it wouldn't capture countries' own costs of participating in the lawmaking process. And it also doesn't capture the costs of the decades of prior initiatives that the CISG was the ultimate culmination of. So there were two failed Hague conventions in the 1960s, and the first efforts at having a law like this were traceable all the way back to the 1920s. So coming up with something new that is as widely adopted as the CISG would cost a lot of money, and it would take a lot of time. In suggesting that the CISG can govern these kinds of transactions, I think that it couldn't do so effectively without really becoming better known and better used by lawyers and merchants at the same time. And of course, we don't know how much of this trade has disputes resolved by arbitration, so it's not visible, but certainly what's happening in Australia through our court judgments we have available, it does suggest it's underutilized now, and that is a practical limit on my analysis.
Yeah, thank you. That's very interesting approach. So I guess we should rather look for judicial interpretation of the relevant provisions of the CISG, as well as COLI writing, etc. So
yeah, that's right.
That's really great.
And I know Camilla Anderson from the University of Western Australia writes quite a lot about the idea of the global jurisconsultorium, that we have this melting pot of arbitral awards and case law in different countries and scholarly writings that all contribute to our understanding of the CISG. So as an input, I guess whether it would be embraced by arbitrators and judges, that would be a separate question, but at least my work will be an input into that process.
Okay, great. Thank you. Thank you again. Thanks.
My pleasure, Jadranka.
Thanks, Jadranka. Are there any other questions for Ben?
I might ask one.
Oh, thanks, Michael. Hi.
This is, I'm not sure if this is a question or just sort of thinking out loud about a few of these issues, and it does go back to the first question a bit, this sort of interrelationship between goods, data and property. You know, I guess goods are always property. But does that mean data is always property?
Yeah.
And then I was sort of thinking about the, you know, the constitutional guarantee of just terms if the government acquires your property, which is obviously off topic anyway. But yeah, so yeah, I just sort of found that interesting, the sort of the interrelationship between the three, goods, property and data, because presumably data might be of no use or value to someone, yet is it property for them, and is it goods for them if it's of no value to them, I suppose?
Yeah, it's a really great question, and we can draw analogies with things like, Associate Professor Thomas Newman talks in one of his recent articles about a market player buying incomplete software off another market player with the intention of destroying it, so that they remove a potential source of competition in the market. So the product itself isn't actually useful, but it still has a commercial value. And I guess an answer to the point about the relationship between those things that you mentioned is just like the meaning of the word sale, the CISG has its own autonomous interpretation of what goods means. So what goods are for the purposes of the CISG is meant to be the same across all jurisdictions that have adopted it, regardless of how they treat the meaning of goods under their ordinary sale of goods legislation. So something might be goods for the purposes of the CISG that might not be goods for the purposes of our ordinary law in Australia, or property for the purposes of our law. And for example, the constitutional guarantee about the acquisition of property on just terms, that's very much a matter of constitutional interpretation of what property is, but the CISG has its own meaning of what goods is that may not necessarily exactly align with that, so might not upset that guarantee.
Thanks, Michael. Drossos, I think you had a question.
Thank you. And thank you, Ben. I think it's a very persuasive analysis, at least in the extension from software to data and looking at it from that layer. I think that in itself is a useful contribution. My point, and I'm not sure if you've investigated this yet, I'm not sure, it's not in relation to non-conformity. It's the Article 42 of the CISG, the provision that the seller has to deliver free of any third-party intellectual property claims, essentially. Does that take on a different dimension when you're not delivering tangible goods, and that you're looking at, I guess, more copyright claims rather than patent claims? I don't know much about it. I'm just curious.
Yeah, I have looked at that, and that's one of the provisions I'm looking at in my full paper. So the intellectual property claims referred to in Article 42 of the CISG encompass all types of intellectual property, including copyright. But there's a proviso in there as well relating to the buyer's knowledge. And in a market where it's common knowledge that licensing in general terms is the main mode of transfer, and that it is routine and normal and spelled out in the relevant agreement that the copyright is remaining with, say, the app developer or the person who's put together the audio file or the video file, that proviso would mean there's no problem with a breach of Article 42, because the buyer is acquiring the digital asset with knowledge of the existence of that prior right. So in principle, copyright for example, like you mentioned, is within the scope of that provision. But I don't think it'd be a problem to the CISG's practical application. And some authorities suggest that it may just be that in those circumstances as well, the parties are treated as opting out of that particular provision through Article 6 of the CISG by virtue of the very nature of the transaction too. So there's a couple of different ways that that problem can be solved.
Thanks, Drosos. Is there anybody else who would? I do have a question myself, but I feel like I should wait until everybody else has had a chance to ask. Okay, maybe I'll jump in before.
Go for it, Nicola.
Thanks, Ben. So one question is a sort of a practical question. Do you have any idea of the volume of trade in the types of data that you're talking about?
Yeah, no, I don't have a specific dollar figure at this point in time, but as I progress the project, I'd be interested in investigating that a bit further. But it's been really interesting keeping abreast of legal industry commentary, particularly during these COVID circumstances where business digitization is a hot topic here, there, and everywhere. And this idea that data is valuable, it's now a commodity, this idea that business scholarship is describing data as the new oil, business data is the new oil. I guess it's not a dollar figure, but it gives an example of the perception of its value by industry. Yeah.
Okay, excellent, thank you. And then I guess this sort of tacks on a little bit to Jadranka's question. You've talked about, the sensitivities around an expansive definition of the convention, expanding the scope, given that it's an international agreement between sovereign states. And in response to Jadranka's question, you mentioned that, will arbitrators and lawyers, will they run with this idea? Do you anticipate, or have you come across sort of any other sectors of resistance, any likely countries or new interests perhaps that are likely to resist this, or the opposite, or sort of provide some momentum?
Yeah, so in terms of jurisdictions that are really engaged with the CISG or not at a more general level, and I think that might partially answer the question, it seems to differ country by country. So the empirical evidence, and there's none for Australia yet, and that's a subject of a different research project I hope to undertake. It suggests that China is particularly on board with the CISG, and relatively recent reforms to its own domestic contract law have aligned that contract law with the CISG. So there's some empirical evidence that that Chinese firms have relatively greater interest in the CISG. If we look to data from the number of cases that are available, there's a number of European centres, Austria, Germany, Switzerland, that have a relatively high number of cases. Empirical evidence from the US and Canada suggests that engagement with the CISG there is relatively low, similar to what we presume the position is likely to be in Australia. So it really varies country by country. So you can't make too many assumptions that the practices in one country reflect practices more broadly. But what I'm trying to do in my article is really make sure that my analysis doesn't mean that the CISG is going to apply to types of transactions that it's not well suited for. And something that I like to think about, without making any claim to have been at the 1980 Vienna Sales Convention, it was 3 years before my birth, and not having any insights into the subjective mindset of the drafters, would it really be any more surprising to them, I wonder, that data could be captured as compared to smartphones or smart TVs or electronic cars? Maybe not. I guess those kind of goods probably might have been equally unforeseeable to them at the time. So my objective has really been to see if we can extend its application to this important area of commerce without taking so broad an interpretation that it's governing types of things it really shouldn't. And in my full paper, I'll be outlining what those limits are and what kind of transactions aren't within its scope as well.
Okay, thank you. All right, I'm aware that we've come to 3 o'clock, but we did start a little bit late. So if anybody does have one last question, then we would have time for that. Take that as a no. So thank you, Ben. That's really interesting. And I know and I'm sure many others are going to be looking forward to reading your paper and the sequel of both papers. Thank you so much for everybody for coming. It's really great to see so many people turn out and obviously get an opportunity to hear what Ben had to say. So I hope we see you all again in the future. Thanks very much.
Thanks very much, everyone.